today's episode, we have Mr. Pankaj Jain, who is one of the senior persons who looks after the RERA, and he is an expert into it. So, welcome Pankaj ji to our today's video podcast show. So,
Thank you, Mr. Das.
would you please introduce yourself?
Yeah, by profession, I'm an accountant, company secretary, and alumnus of the IIM Calcutta, and I'm also a certified corporate director. And after working for around 29 years in various corporates at top level, at director, CEO, vice president, CEO. So I started my consulting in 2016, and primarily I focus in RERA consulting since then. Although I extended in other areas also in real estate and some other consulting vertical I also created for MSME. But yes, in RERA, I have created a lot of expertise, and you can say super expertise. And as of now, I have completed 170 plus real estate projects under RERA consulting.
We are honored and privileged to have you with us today. So basically, the intent of the questions would be how we can help the Indian real estate industry in delivering projects on time with world-class quality. I think RERA, with the introduction of the RERA only, this became feasible, as well as some sort of commitment to the customers, because before RERA, it was a total chaos. So I'd like to start with, how does RERA impact real estate developers and builders in terms of project registration and compliance?
So if you see the impact of the project registration, and it's how the developers have been disciplined. So first of all, the cash flow mechanism has been created under RERA. So that is very, very important, because you know that all of the problems in real estate sector, which has you can say a root cause of the real estate sector, has been the some not a very good planning and utilization of the cash flow. So now the RERA has ensured that under a regulated and disciplined cash flow mechanism, which is dependent on the certificates of the three professionals. So RERA is now ensuring that at least 70% funds of the projects are dedicated to the utilization of the project only. So I am sure that by following this particular cash discipline, a lot of projects are come on the track. And now developers are also complete their projects in time, because if they expand and utilize their 75% funds on that particular project only, so definitely they will be able to complete their project.
Thank you. Thank you so much for the very straightforward answer. Going forward, what are the penalties and consequences for developers who fail to comply with RERA registration?
As a matter of fact, the maximum penalty under RERA is for non-registration only, because RERA has the two categories of penalties, and all the penalties of the RERA are invariably linked with the project cost. So whatever is your project cost, so penalties are categorized into two categories. One is the 10% of the project cost, and others are the 5% of the project cost. So 10% of project cost is linked for the non-registration of the project. So if you are not registering your project, and then RERA is have the authority to impose a penalty to the tune of the 10%. So that is a category one. Now for all other non-compliances under various provisions, so RERA has the second category of the penalty, that is a 5%. Now there is one very exceptional penalty also, that is a imprisonment. That is also, if the one is not following the orders of the RERA tribunal, so then definitely there is also one provision of the imprisonment. That is a one very exceptional penalty of the third category there, where RERA is also empowered to levy the penalty of the imprisonment.
Fair enough. Fair enough. I think. Thank you so much. Then moving forward, how does RERA protect the interest of home buyers and investors in the real estate market?
So as I mentioned earlier, first of all, by ensuring and instilling the financial discipline through cash flow mechanism. So that is number one, the interest of buyers are protected, because their funds are not diverted, which in many projects we have seen earlier, and that has been root cause I mentioned. That has been root cause of the many stuck real estate projects. So that is very, very important that the RERA is ensuring that through cash flow mechanism, if 70% funds are deployed or dedicated or expended in the particular project. So by that way, the interest of the home buyers are protected. Secondly, now by registration of the project, the now buyers have the accessibility of the some critical information and documents related to the project, which earlier it was not possible. So now the buyers can see, buyers have through by visiting the concerned RERA website, they can access that what is the current status of the project. They can access what is the status of their approval. They can access even various certificates on UP RERA. All the three certificates are available, so even the buyers can access that what is the as per their latest CS certificate, what is the status of the collection of the money, and as far as the spending of that money. So by all this accessing all these kind of critical data and documents, so again the buyers are now in a very, very win kind of situation where they can decide further course of action.
Correct, which was very much required. I mean, so going forward, what is the process of filing a complaint or grievances under RERA, and how does the dispute resolution mechanism works?
To my mind now, maximum now this RERA authorities have made their online system. They have come in with the website. So now the buyers in most of the cases where the offline facility is concerned, I think that are very exceptional ones. So naturally, the buyer have to file the complaint offline basis. But in maximum cases, now online facility is now available. So the buyers can visit the particular website of the RERA. They can choose the particular option that how they can file the complaint. So there is a particular option is coming there, and by choosing that option, they can upload their all information, all the documents, and by paying the deposit fees, which is very nominal. The fee is very nominal for buyer complaint. So by doing all this, they can file complaint online, and even now most of the RERA is also doing the virtual, conferencing hearing. So they can also attend hearing online. And in cases where even the hearings are online basis, the RERA is not insisting to have any kind of counsel or advocate or any kind of your representative. So RERA is also allowing the opportunity to buyer itself to present your case. So by that way, they can also present their case and get the relief from the RERA.
Also, which is very good. I mean, if somebody can attend online, nothing like it. I mean, if you're sitting at home, you can have the meeting, right?
Right.
Yeah, thank you so much. So going forward, can you discuss the roles and responsibilities of real estate regulatory authority in different states and union territories?
The RERA, this you can bifurcate the RERA mechanism on 3-tier basis. The tier 1 is the central level. So there is a central act, Real Estate Regulation Act 2016. So that is at central level. Then under this particular act, under the central act, the second tier is the state. So the act has mandated for all states to make their own rules, because land is a matter of the concurrent list in Constitution of India. So the center and state both are involved. So the center has given this mandate to the particular state to make their own rule within the ambit of the central act. So that is tier 2, where state has to make rule. Now the RERA authority comes in the tier 3. So in tier 3, within the central act, within the state rules, now the particular RERA comes into the picture. So now particular RERA, the role and responsibility of particular RERA is to execute the central act, to execute the state rules. And for doing such kind of execution, the RERA authority is also empowered to make necessary regulations as they deem fit to execute the central act as well as state rules. So the particular role and responsibility of the RERA authority is to execute the central act as well as the state rules made by the this central government and particular state government for RERA.
Fair enough. Fair enough. Thank you so much. Now moving forward, what is the significance of the RERA registration number for a real estate project, and how can consumers verify this information?
Up to my mind, I always say that beyond compliance, the developer should look RERA registration beyond compliance, because if they register themselves and they update and upload all the data and documents on the RERA website, through which they can create their own corporate brand also. Because by making this compliance, at least they can create some kind of differentiation for the buyers, because by accessing this information, by comparing this information on the RERA website, so if you are having the good compliance, so definitely you can have a good image, a good perception in the eyes of the buyers. So as far as buyers are concerned, the buyers can verify their particular registration. They can verify the particular details of the registration and even the registration number, even their registration certificate on the website of the particular RERA. So they can visit the website of the particular RERA and then can have the details for the project as well as for the promoter.
Correct. So now, how has RERA affected the transparency and accountability of real estate sector in India?
As far as transparency is concerned, the RERA has done a great job, because earlier, as far as this cash flow mechanism was there was no such mechanism. And first of all, to start with, there was no regulator in real estate, because real estate is have a the promise in India. If you see the current status of the real estate, by 2030, it is expected to touch $1 trillion business. There will be $1 trillion, US dollar market in India by 2030. So it is a big market. And if we compare in terms of GDP, it will be almost 20% of our GDP. So it is a significant, significantly important market as far as our country is concerned. So to make such a sector in a regulation and in a discipline, the RERA has played a great role as a regulator, and RERA is currently in a very evolving stage, and it has not implemented, and it is not come up with the very harsh kind of thing. In many states, it has still very proactive towards developers, towards buyers. So by that way, since the mandate of RERA is not just a regulation, the mandate of RERA is also for a development. So the RERA responsibility is for regulating as well as for development. So as of now, in RERA 1, the RERA has focused on compliance part, but now RERA is slowly moving on RERA 2.0. In 2.0, the RERA is coming more on the compliance as well as on development part. So I'm sure by doing all these kind of transformation, there will be the RERA will help the real estate sector to transform real estate sector as well, not only RERA. So by that way, some kind of transparency, accountability will be created in the real estate sector, and all the stakeholders, including developers, buyers, investors, everyone will be benefited.
Fair enough. I think pretty much detailed information. So moving forward, can you provide some examples of successful cases where RERA has resolved disputes and ensured justice for home buyers?
Yeah, so if you just take the snapshot, because the Ministry of Urban Housing and Affairs, they regularly issue the report card of RERA on monthly basis.
Okay.
So if you see you check their report card, so you will find that the percentage of disposal of the complaints in RERA is very high comparing to the normal courts. The disposal rate in the RERA is very high. Even if you say you compare the state like UP, which has the maximum number of complaints, because UP is a state where in all India basis, the maximum number of complaints are lodged in UP only. So if you take the last report card, so 43,000 complaints have been successfully, disposed by the UP RERA. But yes, as far as implementation is concerned, yes, the percentage of implementation is little low, but not like that. It is not so much heartening. Yes, it is heartening as well, because lot of buyers have got the money by way of refund. So as of now, close to 190 crores RERA has realized, UP RERA has realized in their bank from the developers by issuing the recovery certificates. So naturally, that money goes directly to the in the pockets of the buyers. So that realization is a very big success story, because the buyers who are not getting any kind of relief, so now they will get their money in their pocket. Number one. Number two, the buyers who look for the possession, but they were not getting any kind of delayed penalty. So now they are getting their possession along with delayed penalty. So there are number of cases where buyers have got the possession along with delayed penalty, which before RERA regime, it was not easily possible for the buyer to claim their penalty, because RERA had made a very disciplined and structured process. What is the rate of interest? How delay penalty will be calculated? So they have put all these kind of metrics. So that made the job of claiming the penalty very easier. So by that way, there are success stories by way of getting the possession as well as getting by this refund. And even in some cases where some person has get the possession and still they have some problem related to the quality of the project, some other problem. So by that way, the RERA is also helping that how those kind of issue can be solved even after getting the possession. So I think by that way, in normal course, it was not very easily available to the buyers. So now buyers have very good, mechanism and some kind of system, dispute, resolution mechanism by which they can resolve their all such kind of problems.
Correct, which is a huge figure, as you were telling the amount that is being collected. It's a huge in terms of monetary collection, right? So now moving forward, what are some of the common challenges and criticisms associated with the implementation of RERA?
The first and foremost challenge was coming this, you can say the slow in the pace of the implementation, because initially a lot of states were reluctant to implement the RERA. So that was the first and foremost challenge and even criticism for the RERA, that the pace of implementation was not as much as would have been. And but of late, by the push of the our judgment system, the push of the center, the push of the other forces. Now, a lot of states have been implementing this, RERA, and they have established the authorities, they have established the websites, they have established the tribunals. So now, as per the latest report cards, maximum states have covered all these criteria, and some states are in the process. So more or less, there was a time delay, but yes, देर आए बट दुरुस्त आए, वो काफी जो अपने स्टेट्स हैं वो धीरे धीरे उसमें आ रही हैं. So that is the delay in the implementation. That is number one. The number two, this critical and this aspect and criticism which RERA got was the dilution in the act. So what happened that certain state rules have given some kind of leniency in the in the provisions of the Central Act, because Central Act was having very straightforward provision. The projects which have not received OC or CC as on 1st May 2017 were invariably covered under RERA. But some states have given some kind of leniency that if one particular date they have applied for the CC or OC, or they have completed their development work, or 60% registry they have done, then they will not be covered under RERA. So naturally, there has been a criticism that by making this dilution, as many projects have been exempted from RERA, which otherwise would have been covered under RERA as per the Central Act. So these are the some common criticism which RERA faced.
Because the Central RERA Act was a sort of guideline, and states were empowered to implement and make changes to the regulations as well, right?
No, Central Act is not a guideline. It is a clear-cut act, and the act has the clear-cut provision that you can make a rules, but you cannot dilute the intent and you cannot dilute the impact of the rules. The rules are to support the execution of the Central Act.
Okay.
So, but in the process, some states have made that kind of dilution. So that's why the criticism was made.
Fair enough. Now, going forward, how has RERA impacted the pricing and affordability of properties in the real estate market?
As far as pricing and affordability is concerned, so I have little contrary view, because what RERA has done, by the advent of the RERA, now many developers are not finding themselves compatible to work under the RERA regime. So that were the small time developers. So now those small time developers are now out of market. So in my view, that as far as pricing and affordability is concerned, RERA has made an adverse impact, because all, if you say the number of developers, the number of players in the market, Now the numbers of players and number of developers in the markets are few.
Yes.
So when the numbers of players and number of sellers will be few, then slowly the market will be sellers dominated, and that is happening exactly right now. So earlier it was a buyers dominated market. Now RERA come. Now slowly the market is going towards a seller dominated market. So as far as RERA is concerned, but yes, good part is that now you will have the assurance. Now you have the surety, at least, that even if you pay the higher price, so at least you will get the house. So earlier you were giving the low price, but a lot of projects got stuck. So if you paid the low price, have not get the house, ultimately you are a loser.
Correct.
So now, as far as pricing and affordability is concerned, yes, it is little higher. But on the other hand, due to assurance, due to possibility that you can get your home within some timeline. So now, if you compare both, so I think if you take this your question in isolation, yes, pricing and affordability has gone. But if you consider on the value wise, how this value has been created, so equivalent value has been created by way of assurance of the projects being delivered in time. So by that way, it has been compensation.
Fair enough. I think, yeah, well said. Now, going forward, are there any recent amendments or developments in RERA that interviews or interviewers should be aware of?
This RERA's recent development, I have already mentioned earlier that now RERA is transforming from RERA 1.0 to 2.0. In RERA 1.0, they focused on the compliance part. So now in RERA 2.0, apart from compliance, now they are trying to focus on the development part. So for developing of the real estate sector, so they are also trying to taking some kind of initiative. So now one initiative, I think you have heard also. So that has been started by the UP RERA in 2020. That is a grading of the promoters. So now recently MahaRERA has also, MahaRERA has also informed this that they will also, start a process of the grading of the promoters. So I think that is a very good step because if you will start grading of the promoters, so at least a general public, a buyer will be able to know that who is the good promoter and how they can compare the between various promoters based on the certain parameters, because a common person is not able to make a differentiation because there is a complexity of the information and documents. So although it is as far as its implementation is concerned, there are certain kind of challenges, but I think that is a very good step which RERA is trying to do. So by doing all these kind of changes, so I think the RERA will be a more impactful.
Fair enough. Moving forward, last but not the least, what advice would you give to prospective homebuyers to ensure they make informed decisions and protect their interest under RERA?
First of all, the simple step and simple tip for the buyers is to check the RERA registration of the particular project, because that happened earlier. The most of the buyers have, even now I have seen that many buyers without checking the or verifying the RERA registration of the project or of the promoter, they invest in the project. So I think they should not repeat such kind of mistake again. They should, everything is now available on the RERA website. So before making any buying decision, they should simply verify the credential of the registration of the promoter and particular project on the RERA website. And not only by checking the RERA registration number, they can also vouch the other details, because other details related to the promoter, other details related to the projects are also available on the website. So that is number one. They should compare all these kind of details. Now, second very important thing is that these buyers are required to pay the amount of any unit under RERA regime based on the carpet area basis. So still, as far as industry practices are concerned, due to the compulsion of the RERA, buyers are declaring carpet area, no doubt. But apart from carpet area, they are still using the terminology of the built-up area, super area, which in the minds of the buyers make lot of confusion.
Yes.
So buyers should take very, very, careful decision that before taking any decision, they should compare apple to apple. They should compare what carpet area developer A is giving, what price he is charging, what carpet area developer B is giving, what price he is charging. And as a matter of fact, details of carpet areas are available on most of the websites of the RERA. So they can cross-check also whether this information is correct or not. So I think by doing all these kind of judicious buying decision, the buyers can protect their interest.
Correct. I think, thank you so much. We have indeed had a detailed discussion. Basically, it is from the buyer's perspective. We need to be providing them enough information. And also, I would like to comment in the amendment part, whatever possible. To start with, whatever has to be done, needs to be done, has been already taken care of. But going forward, we need to be including all the specifications of the materials that is being used by the builders in the RERA registration, so that customer has got a clear picture as to what he is going to get going forward at the time of delivery. Yes?
Yeah.
So your one-liner statement for the buyers before we conclude.
The one-liner is be aware. Now you have the mechanism. So it's not one liner, just two words. Be aware. Now you have the mechanism, you have the option. So be aware and take a judicial decision. After all, it's your money.
Fair enough. So thank you so much, Jain Saab, for coming in for today's interview. Looking forward to meeting you again. Signing off for now. Thank you.
Thank you.